Doesn't the statute make them that in some way? I mean, this goes to a question about the ordering and the steps and what the government's view is about how much judges have to defer to the commission's views on this.
That's exactly where I was going, Your Honor. So if you look at Section 3582 C1A1, you'll see that there's actually two threshold findings that a court needs to make before the court is going to be empowered to look at the 3553A factors and reduce the sentence. One of them is that the court has to find extraordinary and compelling circumstances, and the other one is that the court has to find that a reduction would be consistent with the policy statements of the Sentencing Commission. This court's decision in Coons against the United States, I know there are two cases with similar names, I'm talking about the one with an S, addresses exactly identical language that appears in 3582C2 and calls it language of limitation. And I think it's even more so here, because the district court has to make an independent evaluation, even if there is a policy statement addressing it, of extraordinary and compelling circumstances. And of course, I'm sure petitioner would agree that the court has to make an independent determination of it, because otherwise, if there were no applicable policy statement, which is what the Second Circuit found in the context of petitioner's case, there would be no way to grant any sentence reductions at all, because no sentence reduction.
You'd certainly have to make an independent judgment where there were no circumstance or no policy statement. But I understood petitioner to agree with Justice Kavanaugh that if there were such a policy statement, the court would have to defer to it.
Well, if there were such a policy statement, Your Honor, it wouldn't change the structure of the statute. And the structure of the statute very clearly and explicitly lays these out as two separate steps. So the court has to itself find extraordinary and compelling reasons, and then it has to see whether its finding or the other any of its other anything else it might do with regard to the sentence reduction. There are some additional constraints the Sentencing Commission has replaced on reductions are consistent with what the Sentencing Commission does. My point is that we know they're independent steps, and the reason that someone like petitioner was able, we think incorrectly, to get a sentence reduction even in the absence of any policy statement, that is, the absence of any commission definition at all of what its view of extraordinary and compelling circumstances are, is that these are, in fact, two separate steps. So it's a particularly inappropriate circumstance to completely defer to the commission because, of course, the commission is only telling us what it thinks are extraordinary and compelling circumstances for purposes, for purposes of limiting the statute under its own policy statements when the court gets to that second step.
On that second